Hello, everyone. Welcome back to the UPC Insights, your go-to podcast for the latest developments in the unified patent court practice. I'm your host, George Walden, and today we're diving into a landmark decision by the UPC Court of Appeals that could redefine the court jurisdiction over damage claims. On January 16, 2025, the Court of Appeal issued a pivotal ruling in the 5ECL versus the REEL case, confirming that the UPC can determine damages even when liability has already been established by a national court. Now, this raises crucial questions about the boundaries of the UPC's authority and its implications for patent holders and defendants navigating the traditional regime. Before we dive in, I'd like to flag a detailed analysis of this decision on Tilman's UPC blog. You got to check that one out. As published this Tuesday on our Meissner Volta website. So be sure to check it out for deeper insights. It's great. Now, let's get started. Tilman, our listeners might remember our earlier discussions about the handling of the auxiliary requests at the UPC. I understand there's been an interesting development in the case before the Munich local division involving 10 times genomics and nanostring technologies. Could you share the latest update and how they might impact UPC practices moving forward before we turn to our main topic for today?
Yeah, sure, George. I think it's a good idea to have an update on this topic. We had, I think, maybe 1 month ago or 2 months ago, a podcast episode on that.
Right.
And
definitely.
It's always an interesting question. How many auxiliary requests are recommended to file at the UPC? And again, we have a very interesting case. This recent case or this recent development highlights actually these challenges, I would say, and standards for handling auxiliary requests at the UPC. In that case, you mentioned the claimant initially filed a staggering 55 auxiliary requests.
It's crazy.
If you remember our last episode, I think the record was, and still is, probably 80 something.
Yeah.
So 55 is a lot. The defendants, of course, contested this number and argued that it contradicted the streamlined and efficient process envisioned by the UPC agreement.
Right.
Interestingly, and this was a tough or harsh decision, I would say, and interestingly, the judge rapporteur ordered to limit the number of auxiliary requests to a 1-digit number.
Oh, okay.
So actually 9 or less, which is not a lot, I would say. I mean, we talked about this in the...
Yeah, we talked about it in depth, yeah.
Yeah, 9 or less would be extremely low, in my opinion. However, following a review by the panel, this order was revised. You must know that normally for most of the orders which are decided by the judge rapporteur only, you have the possibility to request a review by the full panel. This was performed in that case, and then the full panel concluded that the reasonableness of the number of auxiliary requests depends on the specific circumstances of the case, such as the complexity of the counterclaim for occasion and the number of invalidity attacks raised.
Makes sense.
So for us important, this panel, as many other panels, by the way, left room for flexibility and stated that auxiliary requests subject to EPO opposition proceedings. There was ongoing EPO opposition proceedings. At the time of the decision would still be allowed in the UPC case. So interesting for us, and maybe a takeaway is, in case that you have a parallel EPO opposition, there's certainly, at least according to that decision, more freedom to present more than at least 9 auxiliary requests, maybe 20 or maybe even 55.
Yeah.
I don't know. Actually, I don't know whether they still presented this 55, but more than 9 should be okay. Yeah, so far as to that update.
Well, now coming to the main topic, what is the jurisdiction at the UPC then?
Yeah, let's start with what it's jurisdiction, maybe at least a few sentences.
Okay.
Jurisdiction or the competence of the court relates to the question whether or not any given court, in that case the UPC, is even allowed to hear your case. This means jurisdiction competence. And what governs jurisdiction at the UPC? The UPC's competence is defined in Article 32 of the UPCA, the Unified Patent Court Agreement, and grants the court exclusive competence over certain actions related to European patents and supplementary protection certificates. This includes, of course, patent infringement actions, invalidity actions, so revocation actions, and also actions for damages. However, in that case and many other cases, jurisdictional boundaries can or do overlap and conflict with national court competence.
As we see.
as seen in a recent case I would like to discuss with you originally of the Hamburg local division. And in that case, I would say it's rather interesting to see how the Court of Appeal again interprets these boundaries, particularly with regard to acts of infringement predating the UPC's entry into force.
So what makes the recent decision you mentioned so significant?
Yeah, well, this decision of 16 January 2025 by the Court of Appeal clarified two key points. First, the UPC can actually adjudicate separate actions for damages even if the infringement and liability was established by a national court before the UPC came into force.
Wow.
And second, the court explained to us that it has jurisdiction over acts of infringement committed before 1st of June 2023, provided that the relevant European patent was still in force on that date.
Okay, that's interesting. So how does the decision align with the goals of the UPCA? And tell us about that.
Yeah, well, one of the primary goals of the UPC agreement, or the court, the Unified Patent Court, is obviously to provide a unified and streamlined forum for patent litigation in Europe, in the European Union. And by asserting jurisdiction over damages claims following national court judgments, the UPC is actually reinforcing its role as the central authority for those patent disputes. And this decision also addresses the practical needs of patentees who often face fragmented litigation processes. It's a step forward, I would say, reducing procedural inefficiencies and ensuring consistent application of law across member states of the European Union.
You know, it sounds crazy now. It sounds like the UPC has just gone crazy with everything. Now you have one situation where you have control, and then you have another where you can get damages afterwards. So what are the implications for a temporal jurisdiction?
Yeah, I mean, this decision highlights that UPC's jurisdiction is not confined to acts of infringement occurring after 1st of June 2023.
Okay.
Instead, its temporal jurisdiction extends to earlier acts provided the patent remains in force. And this interpretation, again, is rooted in Article 3, according to the Court of Appeal at least. Rooted in Article 3C UPCA, and ensures that the UPC can address ongoing disputes involving European patents. This, of course, is particularly critical during the transitional period because then patentees can actually navigate parallel jurisdictions with national courts.
Yeah. So how does the decision address forum shopping concerns? I'd be curious.
Yeah, I mean, forum shopping is a common thing in the end, but always raises concerns and has always been a concern in patent litigation specifically. Critics of the decision worry that allowing patentees to seek damages in the UPC for earlier national court cases could encourage strategic jurisdictional choices.
Yeah, I would think the same.
However, the Court of Appeal emphasized the need for consistency and harmonization and framed the UPC as the most appropriate forum for resolving such disputes under unified substantive and procedural rules. And in the end, at least according to the Court of Appeal, this approach aligns with the objectives of the UPC agreement while minimizing the risk of fragmented adjudication.
Okay. Now, Tilman, the Court of Appeal's recent decision, by overturning the first instance, kind of enlarged the jurisdiction of the UPC. Is this a general tendency in your view? I mean, wow.
It's a dangerous question.
Your laugh says it all. Yeah, okay.
Yes and no. I mean, it's a question you cannot provide any other. But I would like to elaborate on that. I mean, a general tendency would require a certain bias, right? Which would be a little far-fetched to assume for a serious and highly reputed court like the UPC. On the other hand, in a certain sense, you may say there might be a tendency in that it appears as if the Court of Appeal places considerable weight on the intrinsic purpose of the UPC, namely to streamline and harmonize patent litigation in the European Union. And if you bear this in mind, it's maybe not surprising that the Court of Appeal has a certain tendency, let's call it tendency, based on a more purpose-oriented interpretation to assume jurisdiction even in borderline cases. An example of this might be also, by the way, the Helsinki case.
Okay, then you're going to have to enlighten me. So what is exactly the Helsinki case?
Yeah, well, it's a case which happened in Helsinki.
Yeah, well, you're so okay.
The Helsinki case, yeah, was in the end another significant milestone for patent holders in UPC proceedings, because also in that case, the Court of Appeal's interpretation of Article 83 UPC-A, so UPC agreement, broadened the scope of what you can do in front of the UPC significantly.
Wow.
In that case, the court clarified that actions lodged before the UPC's entry into force do not prevent the withdrawal of an opt-out. Opt-out, again, we had this maybe in the past. Opt-out means that you say to the court, actually, I do not want to have your competence. You can withdraw this opt-out once, but you cannot withdraw it whenever you have started a national court proceedings. Again, an exception to that was found by the Court of Appeal, and thereby broadening the jurisdiction, in my opinion, at least in comparison with the first instance, in that they said, well, if the national court proceedings started before the entry into force of the UPC agreement, that's fine. Also, on a side note, the Court of Appeal implicitly at least clarified the terminology opting out from the exclusive competence of the UPC.
So Tilman, then how do you mean that? This is a little bit confusing. Now I'm trying to figure this out.
The Court of Appeal emphasized that opting out from the UPC's exclusive competence effectively means opting out from any competence of the court. Because, I mean, if you take it literally, opting out from the exclusive competence, at least in my mind, it just means, well, court is competent, but not exclusively, right?
Right.
So this would be the literal meaning. But again, and this is interesting to see, again, they applied a more purpose-orientated interpretation and said, well, obviously this means from any competence of the court. Again, the court seems then willing to prioritize the intent and functionality of the UPC agreement over a strict textual interpretation, which aligns nicely maybe with a more purpose-oriented interpretation of the law as discussed in the other case.
So then, Tilman, before we wrap this up, I got to ask you one question. So now, after all this, I mean, what do you think this means in the grand scheme of things? Like I always say, and I know I'm always telling you, it just seems like some things are just happening. It's like, you know, the Wild West, like things, you try to have control on one side with the UPC, but then there's another situation which maybe takes away from that control. What do you think? Or am I just...
Yeah, it's crazy times. I mean, in the end, you should listen to our podcast. That's my recommendation.
Good idea.
You should read our UPC blog.
Yeah, exactly. Every Tuesday.
And you have to be really careful how the UPC develops, and in particular, can never be certain that the Court of Appeal will just confirm the first instance. We have had now many cases where the Court of Appeal diverged from the first instance decision, and very often, also in these two decisions we discussed today, very often in a sense that they actually try to really apply the law as it was intended. One reason for that might be that not all of the provisions of the UPC agreement and also rules of procedure are ideally drafted, and this is normal and this is fine for, let's say, this is the first version of it, and they always try to really speak justice in the end, and not so much to stick literally word for word to what the legal texts are saying.
Right, giving it a little bending room, it seems like.
Yeah.
Well, folks, it's always going to be interesting with us here at the UPC Insights, but that wraps it up for this episode of UPC Insights. We've explored how the recent Court of Appeal decision sheds light on the UPC's jurisdiction over damages claims, and even in cases where liability was first established in the national courts. Now, that's crazy within itself. And this ruling underscores the UPC's central role in harmonizing patent enforcement across Europe and bridging national and unified systems. For a more detailed analysis Like Tilman said, don't miss the accompanying blog post on the Meissner-Bolter website, available now. You can get that every Tuesday. We've always got great stuff for you, and Tilman's got great information coming up every Tuesday, so you got to check that one out. If you found today's discussion insightful, make sure to subscribe and tune in next week, where we'll explore another critical development in the UPC practice. As always, thank you for listening, and we'll see you next time on the UPC Insights. And Tilman, auf Wiedersehen.
Auf Wiedersehen, George. Vielen Dank.
Yeah.